Hello, and welcome to the Center for Data Innovation's event on how policymakers can encourage more robo-lawyers. My name is Morgan Stevens, and I'm a research assistant here at the Center, which, for those who don't know, is a think tank focused on the intersection of data, technology, and public policy. Today, we're going to talk about the potential for automation in the legal industry and the opportunities for new and better legal services and the access justice movement. As it stands today, professional rules of conduct, such as restrictions against the unauthorized practice of law, impede a lot of legal innovations. So we are here today to discuss the opportunities for innovation, potential applications and use cases, and how policymakers can safely amend or remove these restrictions blocking their existence. I am joined today by a wonderful group of panelists. First, Erin Levine, the CEO and founder of Hello Divorce. Lucy Rica, Director of Policy and Programs at Stanford's Deborah L. Rhodes Center on the Legal Profession and Executive Director at Utah's Office of Legal Services Innovation. Mark Hansen, the co-founder and CTO of Upsolve. David Coloriso, the Director of Legal Innovation and Technology Hub at Suffolk University Law School. And Miguel Willis, Innovator in Residence at the University of Pennsylvania Carey Law School and Executive Director of the Access Justice Tech Fellows Program. For everyone joining us today, the program is meant to be interactive, and your questions and comments are most welcome. So if you're watching online, you're invited to submit questions via Slido. If you're watching it on the Center's website, you can see the link at the bottom of the page to Slido where you can submit the questions. And then if you're watching it on YouTube or Facebook, you should see the link underneath the video description. So to get started, a question for the group as a whole. In what areas of the practice of law can technology, especially AI and automation, make the biggest positive impact? And David, I don't know if you want to get started with that one.
Can we just say E, all of the above? I mean, the question is that it's like asking what area of law can writing make the most impact in? As a tool, technology and AI and automation generally are things that can improve almost every aspect of what we do, whether it be providing more time to do the stuff that it's not good at or doing the stuff that it can do more efficiently. So, I think we'd have to focus in on it a little more, but so yes, everything.
And I know Mark has a lot to say on this issue, but substance law, bankruptcy, immigration, areas that touch federal law that are quickly scalable to all of Americans without having to go through the hurdles of each state's regulatory regime.
Yeah, I mean, I think I was thinking about kind of access to justice and the kind of quality control of the software we build, and ensuring that you're not sending people unprepared on their way to file. And for instance, we've helped thousands of people at this point file Chapter 7 bankruptcy, who are living out of their car, who are trapped in abusive marriages, that are dealing with predatory loans. And I think a lot of the times you think of what's the barrier to them kind of changing their life. And if you are able to provide them a tool that lets them pivot and make that life-changing move, then that's a huge win. And you don't even need AI to get there. You don't need AI replacing lawyers to get there. You just need education and processes that kind of put somebody on the rails to help them figure that out and lower the barrier for them making those changes in their life.
I agree with Mark, and I'm sorry about my voice. It's a little scratchy. I finally got COVID, so I'm going to do the best I can here today. Automation doesn't have to be fancy. You don't have to use the latest tool or even build your own to make it effective, to provide transparency and answers to customers, to make your team, your lawyers, your staff more efficient. But automation can't be looked at in a vacuum. Simply automating a court form or a pleading is at worst useless, and at best really confusing and not particularly helpful for the customer. So we really have to take a step back and look at the forms, the pleadings, the process itself. What can we do to help people move through, especially in these direct to consumer areas of law like immigration and bankruptcy and landlord tenant and family law? What can we do to help them move through the system as a whole, as opposed to just helping with one particular piece? that could spin them out into something to an even more frustrating experience.
I will add, however, that at worst, though, it's worse. You can have something worse than useless, because just filling out a form, if that form is, say, something in a context where failure to bring up a certain issue precludes someone from bringing it up in the future, you've just foreclosed someone's ability to assert a right if it was not something that was set. So
let's call it dangerous. At worst, dangerous. Yes. And I agree, absolutely.
Harm can be done by simply doing simple stuff, if you do it poorly.
Mm-hmm. Absolutely. And Erin, I know Hello Divorce has made the divorce process a lot cheaper for a lot of folks. So how can automation kind of impact the cost and affordability of legal services?
Oh gosh, in so many different ways. How about if I touch on a couple? Well, one is simply making the people behind the scenes a lot more efficient. Another is giving consumers the information that they need in order to make good choices that bring peace of mind and help them get through the system. Another is to help them actually prepare the forms they need, get them filed at the correct intervals, at the correct time. But automation and technology can help with so much more, especially when you have companies like Upsolve or Hello Divorce or Trust and Will that are collecting a huge amount of data. This data can be used to help people figure out what their next steps are. So as an example, it can also help them to figure out, to provide them tools for what they need next outside of legal. Because when you have an issue like divorce or bankruptcy, you have far more generally going on in your life than a legal issue. So to be able to aggregate that data and help provide them the resources and information they need on other things that are coming up with this life event is very, very helpful to people. I'm feeling like I need to sneeze. Does somebody want to jump in on predictive technology and how that can be helpful?
So, I mean, I guess maybe as an interesting point is like there's nothing really actually predictive in the Upsolve system. I think like kind of on the issue of quality that came up before, something I was thinking about is I think one thing that automation does really well or is really interesting that we do is we'll basically ask kind of different questions that kind of get at the same point, and the software is kind of doing kind of an analysis on prior answers, current answers, and kind of ensuring that a person has thought about this in different contexts. So I think that's something that I find really interesting with automation. That would be really hard to do as a person, and keeping track of all those different answers. So there's nothing really predictive about us, but we do recognize where the limits are of the tool and really the particular audience that we're focused on. So we know that there's complexity outside the range of the simple sevens, and so we really say, okay, what is the low income, low asset case consider? What's the world that we need to be mindful of, and just making sure that we stay within those boundaries, so that we don't have to kind of do these complex jumps where harm can be done.
Absolutely. So we actually have an audience question about that harm. So do traditional legal aid programs generally embrace these kinds of innovations, or do they see them as dangerous for or potentially dangerous for vulnerable clients?
I think it depends on what you mean by, this is very lawyerly, but it depends on what you mean by these kind of innovations. So we at the law school, during the pandemic helped stand up basically something that worked on similar tools, actually the same underlying framework that both Erin and Mark's organizations used, an open source program called DocAssemble to help automate form filing in Massachusetts when the courts were physically closed. And that was the type of thing that has now been expanding to other states where legal aids are the ones who are picking it up because it helps them do more with their existing resources. But what people do get nervous if they don't understand what it is. And as Mark mentioned, it doesn't, and Aaron as well, it doesn't have to be complicated. Basically giving someone an interactive flow chart is often a very nice way to help them navigate the complexity of something. And so a lot of what I see these tools doing is helping people navigate complexity. And those are not always technical innovations. Sometimes they're practice, practice innovations. So procedure is just as much a part of this as anything else. And there I'll just note that the one thing you have to worry about in these situations is automating bad practice and bad procedure and just automating something that's already there. So one of the best things about these tools is the opportunity they present to examine whether or not the process that exists as it is now is the one that should be there. I mean, Upsolve's sort of pressure and all the stuff around bankruptcy and the New York state development with the recent case where the state ended up producing the one-page form because people needed it. They just didn't want people to help people fill it out. And I don't know if maybe that's a place for Mark to talk about what Upsolve has done around regulation. But
Yeah, so I mean, for the bankruptcy tool, legal aid will refer people to it. So we often see, how did you hear about us? So somebody at legal aid said, hey, just use this instead. So it's like, here's a simple case, I'll save my time on this and then focus on some other place. So we have judges that have referred people to us. We've had clerks, legal aid, lawyers, everybody. So I think it's helpful for helping professionals focus on, where they can provide the most value. And then for, the case in New York, so for those that don't know, we're authorized to have non-lawyers give limited assistance around kind of responding to debt lawsuits. And there's a single page form that the state has that many people just default on this. They don't respond. And sometimes many people are wrongfully kind of attributed to debts that they don't owe. So we've been given the authorization to kind of train people in a limited fashion to walk somebody through that form. Because there can be barriers of accessibility when it comes to language, when someone's unable to read. So just a very low bar of like helping a person fill out the form. It's illegal. And so we're really moving through that process of how do you train that person, how are you having compliance. So not only is we have a tool that the advocates are actually going to be using that's guiding that conversation even through that form. And there's all this kind of infrastructure that we want to build around that to ensure that there's a quality to the engagement as well. But I'll refrain from going on.
I'll just jump in really quickly to say, I don't think legal aid is a monolith on this at all. I've seen really distinct differences across jurisdictions, but there is concern. There's concern about consumer harm. And so, in thinking about how to move forward and how to support automation and, automation in addition to lawyers, automation in addition to other legal providers, that quality concern has to be first and foremost, both for policymakers thinking about regulatory approaches and also for providers such as those as we have on this call.
Yeah, primarily I work with legal aid organizations, courts, and a variety of other stakeholders to develop technology tools and solutions. So, around the nation, you see organizations and different groups, embracing them. There is an infrastructure in place through the Legal Services Corporation's Technology Initiative Grant that has provided funding to organizations, even spun out some really interesting collaborations. I remember we hosted a fellow at PLA that was working in collaboration with Upsolve at the earlier stages of developing their tool. I think overall there is a gap in the leadership, embracing this. So you'll have like a organization, and this varies, of course, from state and organization, but you'll have, a handful of attorneys or a group that would develop a tool, but not have the necessary buy-in from their ED or leadership to get that embraced throughout staff attorneys across the organization. Same with courts. So there's still a lot of work to go in that area. I think one of the challenges is that there's not enough level setting of the extent of possibility and opportunity. I think a lot of folks look to the harms, potential harms, and you hear about AI algorithms in courts and different things that but I try to not be a techno determinist and saying that technology will shape this way. I think we built these solutions and we built the tools, and we can steer the ship depending on how our ethos and our what type of principles are we setting to ensure the reduction of harm, the facilitation of the delivery of services.
I think a sort of perverse situation that comes up a lot of times with this is that new tools are held to a higher standard than existing practice. And so I always like to ask, compared to what? And if the question is comparing, say, an Upsolve's case, a single page form where people can just download it and fill it out on their own, or they can get someone who's had a little training help them fill it out. Well, the question is this new thing, is it better or not? And that's actually really interesting from the regulatory standpoint. In the Upsolve case, that my general taking of the district court's order was that basically context mattered in talking about what they were doing. And so the fact that Upsolve was so careful in how they thought about training their advocates to give that advice meant that the sort of the likelihood that people were going to be helped by it was very much clear. And so context matters. And we shouldn't just assume that something that's new is either going to be great or be bad. We always have to ask, compared to what?
Yeah, I'll just jump in on that really quickly. And sorry, I had a bizarre computer malfunction, speaking of technology. That principle that David raises in terms of compared to what is exactly what we incorporated in the Utah sandbox as one of our key principles. And I call it the relativity principle, which is you have to consider the risk of harm of any service, whether it's provided by a technology or not, relative to where this person what this person otherwise would have access to. And we know that in fact, for the vast majority of people, that's nothing at all. That's not a full representation by a lawyer. So we tried to build that in directly into the Utah sandbox to ensure that we weren't holding new providers to the standard of, say, I don't know, Cravath or whatever it is, whatever people think of as the ideal lawyer provider.
It would be interesting to look
public
at
defender's office. That's my history coming back to me as the ideal lawyer provider.
Erin, were you going to mention something?
No, I was just going to say it would be interesting to look at this a little bit more holistically too, right? There's the harm, and there's like how what is the help? So as an example, we know the vast majority of people in the family law space aren't represented and don't seek or can't access legal advice. With Hello Divorce, 10% of the consumers who use the software at some point in time access a lawyer through our platform and talk to one and get advice before signing and submitting their documents. These 10% of people are the same people that never would have hired a lawyer to begin with. So we gave them access. I mean, they paid for it, but we provided them access and gave them an opportunity to get help on the limited issues that they needed help with so that they could move forward and, have some peace of mind there. So I'd love to look at it from that angle too, that access angle. And I think sometimes it's just viewed through that limited lens of harm. What is the worst thing that could happen in this scenario?
Access, I think that this is something that's been said many times before, but access to justice does not necessarily mean access to an attorney. But for those of us who are attorneys on this call and in the audience, we have an obligation to help promote access to justice. And I think that's important to remember, that our duty is not to make sure attorneys have jobs, it is to make sure people access justice. But on the question of jobs, I mean, there aren't enough attorneys to go around. I always think about Gillian Hadfield's research on this, showing that annual pro bono hours would have to go from an average of something like what they are now, I think were at the time of her study at 90 hours per year, to something like, 30 hours per year to like 900. Like there just is, there's too much work to do. If these tools can help provide access to justice, then on the question of the relativity principle, I think there's a clear winner.
Yeah, and I'm even kind of thinking even further up the chain. So the vast majority of people who start our product and start this questionnaire, they don't file. And so I think there's kind of, I guess, access to justice is also how much education are we providing to people so that they can even understand, I didn't even know what bankruptcy was. Let me understand this. Let me understand what chapter 7 is versus 13. Let me understand my context. Let me understand other options. And that's saving time where, instead of them bringing that conversation and questions to an attorney, they're finding that, internalizing, understanding that themselves. And kind of, I think there can be more done on that kind of education front and helping people kind of steer, or just providing the context to understand their options better. That can save attorneys time.
That could be argued the number one benefit of services and products like Upsolve and others in the industry is this education piece. When people are facing critical legal issues, they are in a state of panic. Sometimes they feel fear, they feel this loss of control. And just understanding what their options are is so major in helping to take down that level of emotion and be able to thoughtfully think about what their next steps are.
Absolutely. And Miguel, I read your post on how, going along these lines, I read your post on how increasing automation in legal services doesn't necessarily mean that we will have increased access to justice. Are there other steps that we should take in conjunction with automating legal services that would help?
Yeah, I think, a lot of stakeholders have, different goals. Courts have different goals than legal aids. Law schools have different goals than them as well. And this kind of points to the question that I think an attendee asked, in terms of the debate versus TurboTax and or should it just be easier, the file taxes. I think the same could be true to just make broad policy changes that, eliminate, certain needs to do, expungement is the perfect example, right? Create this tool, or should we just have a clean slate, period? We can have these discussions all day, but I think it really passes the buck. And I think what we all care about is kind of the material change and help in someone receiving access. So I think focusing on that, where a person is, if you are getting kicked out of your house, you are facing houselessness. If you are getting denied in food stamps, TANF, you are experiencing, the inability to get access to food that you need. So when you focus in on the specific problem and meet, the individual where that problem relies, I think technology, and you embed it within the design and inculcate it within the delivery and outreach scheme of your tool, that's where technology has the most potential. But, you can also make a shiny tool that, isn't really accepted or regarded in the community as a trusted solution. Then there's limits or limitations to its ability to.
Oh, I think you might have muted yourself.
Muted.
Sorry.
Yeah, I think Miguel is completely right. I think I always kind of respond to this question with my, I have a yes and approach to all of this, which is, the market is so badly functioning at this point that we need all manner of solutions, including stuff like what David and the filing fairness thing out of Stanford are working on of simplification of court processes and standardization across different jurisdictions. We need more money for legal aid. We need more pro bono from lawyers. We need more changes to legal education that diversify legal education. And we need automation, and we need more types of human providers at different levels of complexity. So I think what's super interesting is, I mean, Upsolve is such a great example of a lot of this, right? Is that Upsolve is an extraordinary tech tool, but where they're going with this debt collection stuff is, I think, where particularly for folks who are really in dire need, partnerships with trusted community organizations where you have humans trained up to help alongside the technology is I think, particularly for the most vulnerable groups, and to particularly make an impact in that space of access, is where we hope to see the most movement. And we have some similar partnerships in the Utah Sandbox in domestic violence, in medical debt legal advocacy, which is from Stacey Butler's organization, I4J, which is at University of Arizona and University of Utah. And these kinds of partnerships, leveraging tech, leveraging humans, can really, really make a substantial difference. And it's, I think, what people want as well. They want to talk to a human as often as they want to have a tool on their phone. So you need both.
And the human component is so critical, especially in areas of law that are state focused as opposed to federal. So as an example, in family law, every county might have different submission guidelines. And something that we learned when we launched in Texas is how many counties they have in Texas. I've never heard of so many counties. It's wild, right? So every county, and in some cases, different judges have different policies on what's optional or what's mandatory, whether they're okay with e-signature versus not, whether they want the documents to be stapled. We've seen it so far as judges actually inquiring with litigants whether or not they used an online legal service or the help of a lawyer, and not generally for the reason of supporting innovation. So there will always, until there's clear policy change, there will always need to be human involvement. And like Lucy said, I mean, to a large extent, people, that's exactly what they want and need. They aren't just putting together one document. They are, in many cases, being led through an entire system. And that takes a lot of support, far more than most technology solutions can provide.
Which I think it really goes to the truth that the technology is never the hard part in any of these innovations. It's always the policy and the people, and figuring out all the stuff like you were talking about. But I think that Lucy's point about these, and this is my opportunity to push back on the robo-lawyer moniker, because I think it ends up being counterproductive, because it brings up ideas of like the Terminator. But really, I think what we're looking at is like a power suit, so something like Iron Man. These are tools to help people do things that they couldn't do without them. And whether or not that's freeing up time because they actually do the thing entirely, it's very rarely that they do it all entirely, or just helping you do things better. I think that's an important distinction to make. We're not trying to talk about robo-lawyers as the Terminator. It's more like a power suit.
The Autobots, if you will. Mark, did you want to mention something?
Yeah, just a lot of awesome thoughts. I mean, I guess two quick things. I mean, one was kind of on touch points, and I think like for us, the starting point and like them being the touch points and the initial are not lawyers. So for financial hardship, you don't want to talk to anybody about that. You're trying to dig yourself out of that, right? As a culture, I'm gonna solve this myself. And so people start their search online, and so content is our kind of entry point for basically all of our users. The biggest being about wage garnishment. It's like one of our most important articles. So that's been like the big piece. But obviously there's many languages to be writing content in. We haven't touched every single language out there. And that's where I think like the non-lawyer of someone in, a pastor can, in conversation with someone in their congregation, can just be that kind of, can advance that person down a path to improving their life. And then on the kind of other point around automation, like very much can feel that we have a district that was rejecting petitions because we didn't center align like one of the pages. So we have like a carve out for that in our code. Yeah, I think like the lack of consistency across districts creates such a barrier to entry for any technology product. I think like our existence is frankly like very odd. Like I don't think like it's kind of a rare, like I don't think like this is the abnormal. I think that Upsolve like has made it and pulled off what we've done. Like I don't think we should think that things are good because Upsolve can exist. It's like it's kind of wild that like we had to build the technology product that we did to pull this off. But maybe we'll get into that later.
Yeah, and I think your product is much more sophisticated than ours is at this point. But just to illustrate the example, we have a full-time compliance person, somebody who graduated Stanford and spends all day, every day trying to figure out what judge in what county, in what district has changed their mind overnight and not posted the new filing guidelines.
So switching a little over to the regulation side of things, we have a question from the audience. How do you frame civil justice tech imperatives, what we want, for policymakers that see constituent issues through life problem lenses or their own agendas?
I think going back to when Lucy mentioned Stacy, I think Stacy Butler did a really good job at her housing navigators and housing curriculum program. She tied in the downstream effects of what not getting legal help would cause on, her jurisdiction. All policy makers and folks in that arena care about those issues and how it affects their constituencies. So putting that in the forefront and having the data to track the downstream effects could be impetus to catalyze more upstream solutions to in addressing some of those issues. But there's a ton of other examples and folks who are doing just that. And I think with some of I remember in Jason Chachet and I believe Scotty was, working on some of these expungement applications and then tying their work in a lot into how to shift the policy on this, and for clean slate. So I think it's definitely should be an approach that should be embedded within. But again, technology companies, courts, legal aids, they all have different kind of ways to this. And if you're a kind of scalable company, I think you're really more focused on your user and your bottom line. Whereas, courts may think about this, but how are those connected with the legislature, and how are those conversations? So I would love to hear others kind of chime in on this.
I just say you meet them where they're at, right? If they have client stories or constituencies that are important to them, then you can make those relevant. The hard part is a lot of the things are sort of things that a lot of people don't find interesting. So when you're talking about data standards, which would make all of these things better, that are a bunch of the different things we're talking about, the variation among courts. That's a thing you say, oh, well, you want it to all be standardized and you need this, and you start talking things like JSON and are we having data types and all sorts of stuff, and their eyes sort of glaze over. But you can meet them where they're at. I mean, we have tools here that, so for example, we built a tool that Someone was in the middle of facing an eviction. They got a housing order, an order from the housing court to be evicted in the morning. They go home. The constable's at the door. They're removing the property from their home. They use our tool to do an e-filing for a stay with the appeals court. They get the stay. The property goes back into the house. It stopped a physical eviction in process. Well, that's a story that says, oh, well, okay, I understand the power of these tools. That was a good tool. But you could have also gone out and said, well, we want to make a tool so that people can file whenever, at whatever time. And we want to do that as accessing the court. And that's true. But you can meet them with the things that resonate to them, as opposed to having to put it in the ways that maybe are how you normally think about it. So try to find those stories, use that power of those stories to meet them where that, and make it clear that it's relevant.
Yeah, I think David's point is a really good one. And I'm not sure exactly who's in the audience for this panel, but to the extent that it's innovators and folks that are trying to build solutions, I would say have that, again, Upsolve is a great example. Have your PR strategy, your advocacy strategy front and center from the beginning, guided by the folks that you're trying to serve and the solution that you're trying to develop, and get on it, because otherwise the narrative is shaped by folks who have a vested interest in not seeing innovation happen, which is what we've seen happen in multiple jurisdictions. And it will continue to happen until more organizations do like Upsolve did and really develop out that PR and advocacy piece, getting those stories of consumers front and center, so that the narrative is not totally defined by lawyers who oppose innovation. And they oppose it for reasons, that are understandable in some ways, concern about harm, all these things that we've talked about. But that's why the organization of innovators like the folks on this panel and the folks hopefully in the audience is so important. And I sit in sort of a different place, but that's, I sort of, as often as I can say.
I think we might have lost her for a second. We'll give her a second. Oh, perfect. Okay.
I'm just having the worst time today with my technology, but anyway, I shape this as kind of a call to arms for folks to really have that strategy, PR and advocacy front and center.
But I'd say I agree with everything Lucy said, but remember you have multiple audiences. So sometimes the thing that you think is a really great story, you might say the story I just said, it makes it easy for everyone to file. You might have some people are like, I don't want more people filing in the court. Maybe that means more work for me. And so you've got to say, well, what's in it for them? So maybe the thing is that you're making pro se applications easier for the clerks to understand and navigate, so they don't have to wade through narrations that they didn't understand. So the key part is know your audience and tailor it to them.
Absolutely. And going more along the lines of the regulations, there are a few such as restrictions against unauthorized practice of law, Model Rule 5.4 restrictions. Should policymakers change those, and how can they do so while still protecting consumer welfare? And Lucy, I don't know if you want to take that one first.
I was holding back. I mean, obviously, I think the answer is yes, but and that's sort of what I've been doing for the past 4 or 5 years. So yes, I think so. I think there's different ways that states and other jurisdictions globally have attacked this. There's Dr. Tom Clark and I put out a kind of regulatory choice framework paper a couple months ago. It's on the Rody Center website, but there's a lot of different choices to be made, and each jurisdiction really has to think about, what its priorities are and what it really wants to do. What we did in Utah was try to create something that was really driven to allow the market to work while focusing on protecting consumers from harm, identifying when harm is actually occurring, as opposed to deferring to the ethical rules as sort of proxies for consumer harm. They aren't actually about harm, but really trying to identify consumer harm and then allowing both unauthorized, what would have been understood as unauthorized practice of law, and non-lawyer ownership to take place. That's one approach. And, we've really been driven by the goal of allowing the market to have more of a role here, more of a functional role, and to really allow innovation to be prioritized. But there are other approaches. Obviously, Arizona took a different approach, and we'll see what happens with other states such as Michigan and Washington and North Carolina. So I think the key is that we need, what we know that we need is more diversity within this market, and we need more capital brought to bear in ways that are more flexible than is currently allowed, if we really want to see innovation at scale. The other big challenge, of course, and we touched on this before, is the multi-jurisdictional problem. Utah and Arizona are just two states. We have a lot going on in both states in terms of entities coming online, but they're just two states. And so really, to make a difference in a lot of those state civil justice issues, we need more jurisdictions to grapple with how they want to make change, and to try to do it in a way that reduces the barriers across jurisdictions.
Lucy, some of the work that I've seen out of the states that I really like is tying it to outcomes. I mean, you talked about that, but could you talk more about that? Because I love the idea of we're not just going to take someone's idea for what works. We'll figure out what we mean by what works and make that part of the calculation.
So within the Utah sandbox, what we've tried to do is say that we know very little about what the outcomes, what we're concerned about is preventing the worst outcomes. We want to create a floor below which we say you cannot go in terms of risk to consumers. But that floor is not, again, back to that relativity concern. It's not lawyers, right? It's somewhere else. But in terms of dictating other outcomes otherwise, we have not tried to do that, because we have said we don't know where the most impact will come from. We don't know what business structures might create the most impact. We don't know what forms of UPL might have the most impact in different populations. And so we've really tried to otherwise have very few upfront requirements or dictates. I don't know if that answers your question.
Yeah, no, I wasn't thinking about dictates. I was just thinking about, well, actually, I guess I kind of was, because I was thinking that you take the approach being that we don't know, so let's find out.
Yeah.
And actually see what happens. And in that way, tie things results. So it's the question of, we can see what happens and then go and use that as information.
Yeah, and that sort of circles back to, at least theoretically, the whole concept of the sandbox is, particularly coming from software development and then also from the fintech space is, these technologies and, the Utah sandbox is about more than technology. It's also about human provided UPL. But the whole idea was, we really don't know how these technologies fit in with the regulatory framework. We really don't know how they may impact consumers. And we want to try and see what will actually happen before we create rules that will unnecessarily cut off innovation. So that's what we're trying.
And one thing I would love to add on that is I love how that is a proactive engagement that you're doing. Because I think one thing that has been, as much as the bar that UPL has set for us, it's been an incredible driver for quality. We've had to create an incredible product to meet that standard. But it basically led to a kind of chilling relationship to some extent. We've engaged regulators and everything, but that's a pretty high bar where you're gonna have to engage federal regulators up front to have this conversation for anyone to kind of engage. And even then you're kind of, there's this kind of looming threat potentially that you're kind of, doing your best to make sure you don't hit that landmine. Or else, here comes that criminal insurance to save us. As an engineer. So I think it's been an incredible thing for that sake. But yeah, we haven't had a proactive engagement. And then what ended up happening is, 2.5 years ago, we wound up finally having a case come forward out of Maryland that basically had us sit down with a judge and walk through every screen of our application and like explain what was happening. And they were fielding questions. So now that's the burden of like carrying that legal cost of like engaging in that, making sure that everything is being fully communicated, and like just the precision we wanted in making sure everything was there, and that we were, that was a lot of work. I mean, it was a 2-year case, and that is not a cheap thing. So what I would have loved is to have a more, without threat of UPL or any sort of other law, I would have loved to have conversations with somebody. And like, is our design UI UX conversations like good to be having through like court documents? No, it's not useful. That's not a way to go. So I would have loved like some sort of department or some sort of just auxiliary thing where we're just constantly engaging and like able to have those conversations of, here's the tool without risk. Can we just have a conversation about what it's doing and get your feedback and your buy-in and that feedback, and not having this, multiple year process where it went through like 2 states for different reasons. So just the design process can't happen through courts right now, and it is.
I have also noticed a tendency on the part of courts who want to be neutral arbiters to worry that any help is somehow putting a thumb on the scale. And I think that if policymakers could reframe that to realize that helping someone get access to their rights doesn't mean you're putting the thumb on the scale. So it's sort of this perverse situation where if it's the little guy who's coming to court and asking, how do I do this thing? I don't think it's not a violation of the court's impartiality to help them know what the proper thing to do is. That unfortunately, that chilling, as Mark described it, ends up benefiting those who don't have to ask the questions, who can pay someone to answer the questions, and so you end up perpetuating inequities that are themselves unfair and impartial.
Absolutely. And speaking of the courts, we had our very first audience question. How much will the success of Robo-Lawyers or tech-enabled legal services depend on the extent to which judges accept their use without prejudice? And are there any guidelines or training necessary for the judges?
In the case of Upsolve, I don't know how many judges know when people file their petitions with our tool. So that may not matter. And similarly with like the debt lawsuits, you file the form with the state and they don't know. If anything, I mean, we constantly get compliments about petitions coming through. I guess the one indicator is that we are very consistent in the fonts and the way all the data kind of gets in, and it's extremely like well documented and clean. So I think people kind of get the idea once they've seen a few that it's Upsolve. But yeah, folks don't know.
I would just say, hopefully, not a lot. I think, if we tend to focus all of our efforts downstream when someone experiences the court, they're at a later stage of that problem, and that problem has kind of morphed into, where they're responding. And this is one of the kind of problems with the law in general. We love to just insert ourselves into every single facet of someone's life, right? But if we're catching an individual much sooner in the process before, they're appearing before court, I think we have a lot of opportunity there. And in those cases, it's really not dependent on a judge, right? So if you look at some of the main causes of why someone is getting that eviction notice, because they can't pay their rent, and what types of programs are there for an individual? Well, there's rental assistance, there's a host of nonprofits and government services. And so how can we embed that early stage? And also, how can we, get trust of other providers? I think Just Fix NYC does an excellent job of really putting the community first in terms of, soliciting support from grassroots organizations, organizers on the ground, legal services organizations. And I think that kind of unanimous support on the ground roots level, you see a lot of buy-in from, stakeholders within. So those are, I think, two examples, but we focus all of our efforts on Robo-Lawyers at the 11th hour before someone's getting evicted. Well, a lot of people will still get evicted. And, to David's story, I think that is great. And I think those stories need to be highlighted and put, used to build, a lot of support and around this movement, but really focusing on how can we prevent people from coming to court or being dragged into court in the first place. Is a really good example or a situation to be in.
I think Miguel's that sort of opens up this other question, and we've sort of been talking about the Robo-Lawyers as if, even though I hate that term, as if it's like this thing that comes in and maybe it's just for helping pro se folks at the last minute. These are all tools that I'm sure people have dual use. That Aaron, I'm sure you have attorneys who are using your tools to help draft their documents. Does anyone think that, like, at some point it's going to be an ethical violation to not use some of these tools? I mean, Mark's saying, if it looks so much nicer, I don't know. I just thought that thought came to me.
We had an attorney, actually. I don't even know if it's allowed or not, but they were sending people to use our tool, generate the forms, and they were doing like a low fee, like review of the forms out on the West Coast for people.
We've seen that too. Yeah.
I mean, I guess it gets crafty at some point. But speaking of that, I suppose like trying to prepare for to use these tools as in, or whether or not it'd be unethical to not do so. How should legal education change to support the development of tech-enabled legal services?
Ooh, Miguel, I bet you got something good there.
No, I think, you see a growing number of law schools teaching courses. I think courses, of course, curriculum around the use of technology, ethical use of technology, putting them in a position to be kind of developers. I'm not necessarily saying all lawyers should code, but putting them in that problem-solving kind of environment. You see law school labs that, such as David's, that are being responsive on the ground level. What they did to develop the forms during COVID, they stepped up, and those types of experiences not only have material benefits to the communities that they're serving, but they also provide an experiential learning process for the students that are involved, both in the development of tech and the other interdisciplinary skills, but also cultural competency and emotional intelligence around just being responsive to some of those issues and working in that collaborative environment. And in terms of like to spin out more hello divorces and upsolves, I think we need a larger scale infrastructure within legal education, right? So how the folks at Duke Law Lab are doing a really good job at getting venture capital companies in the market to serve consumers. Stanford has programs that do that. They have a broader infrastructure, but when you look into other disciplines and industries, accelerators, incubators, all types of kind of structural supports that really catalyze companies to get them into market. And so how can legal education support some of the same, or be more collaborative with other schools on their campus, such as the business school or engineering programs? So I'll stop and shut up.
I think that's so helpful and brilliant. I don't have the answer. I wasn't the best law student. But here's what I do know. one of the first things I was told in law school was, don't let people tell you too much about what's going on in their life because you're too expensive to be a therapist. And right from the start, throughout my entire law school experience, emotional lawyering was seen as a really bad thing. Not only does it make the price go up for the customer, but it's getting into an area of expertise that you don't have. And so the last thing we really focused on is solving problems, really getting to the core, doing things like Miguel said, thinking about how we might be able to help people before they even hit the legal system. None of that was really came through in my experience. And now when I look at lawyers of all types, family law, contract negotiation, whatever it might be, the number one problem that I see is this lack of focus on solving the problem, and that winning in the lawyer's mind might be a very, very different experience or goal than what the customer wants and needs. And so I really hope to see, and maybe there is already, I'm not very up on education these days, except for the very innovative, amazing things that schools like Duke and Suffolk are doing, and Stanford. But overall, I'd love to see some real focus on like how we can protect our wellness as lawyers and have work-life balance, but still get in the weeds with the client and be able to like help them figure out what their goals and needs are and how we can help get them there.
And that's really quickly, that's the goals of the Future of the Profession initiative at Penn. And I think tying all of those things in and really being intentional about that is the goal, because sometimes it's just the tech community or the legal tech folks, and they're working on cool things, but how do you understand the challenges of someone living in poverty, experiencing poverty, and having a host of intersectional kind of discriminations that they face every day? You don't in general 1L classes. And so tying that in, I think we can definitely do a lot to raise the profile. How do you do that quicker? Well, you have more diverse students in your law school. So that brings a whole other topic. I'll defer to David.
Well, I was going to say, this is where I get to be like, well, there is an innovation that does all of these things you want to do. And the thing is, it's been around for 50 plus years. It's clinical programs at law schools. So clinical programs have students actually practice. And when you actually practice, you get all the things that Aaron was talking about. And you see the things that Miguel is interested in. And one of the programs he mentioned, Duke Law, their innovation center, is where is it based in part? The clinics. Where is my lab based? The clinics. So I think what really some of what law school needs to do is, and this is probably a sad statement, that that 50 years after clinical legal education has started as a movement, that it still isn't universally accepted everywhere, and it is not often a large part of people's legal training. But I think there should be more of that. So part of it is, going with the innovations we have, and we have good pedagogical reasons to work with them. I mean, when we're at the lab training people how to code, like Miguel suggested, it's not because we want them to be computer scientists or developers at the end. I always think about a quote from Richard Feynman, which is, that which I cannot build, I don't understand. We're training them, we're getting their hands dirty so they understand how things work, not so they can go out and be coders, but when they understand how the world their clients live and work, and how the tools they use work, then they can use those to, as Aaron says, solve problems. And when they're embedded in a community, as Miguel is suggesting, then you get to actually figure out what it means to empathize with a community. And so I would say legal clinical education, that's where it's at. I'm a little biased, but that's where it's at.
I agree.
Yeah, I agree with all that. I think my one little addendum or addition would be, I think we really want this. I think, particularly the students that we have on campus now, they're seeking a profession that looks different, and they're seeking different ways of engaging with the pedagogy, and with, what their life will look like afterwards. So, Aaron, what you said really resonated, because I hear that from the students a lot, that they don't, this traditional way of teaching, what the plaintiff does, what the defense does, what's the issue spot, like it's not enough. They want to do more of that empathetic work. And it's our responsibility to the profession and to the public and to the students to meet them where they are. So yeah, 100%.
Absolutely. And thank you all so much for coming here today. Unfortunately, we just ran out of time, but I hope everyone likes. I hope you all have a lovely day. And thank you so much for joining.
Thanks all.
Thanks
you.
for having